after today's date that will no longer be using initials in this matter, correct?
Correct.
A Wisconsin teenager was supposed to be escorting a 10-year-old girl back to her home after a visit to her aunt's house, but instead, prosecutors say he strangled her, beat her with a large stick, and sexually assaulted her. His lawyers fought to keep his case in juvenile court, but lost. And now we know his name and questioning what the motive might be in this savage crime. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. We have several updates for you now on the Lily Peters murder case out of Chippewa Falls, Wisconsin. The 10-year-old was riding her bike back home from her aunt's house in April of 2022 with 14-year-old Carson Peters-Berger, but she never made it. The Daily Mail has previously reported that Peters-Berger is Lily's cousin. We haven't been able to independently confirm that, but here's what happened. Lily's dad panicked when his daughter didn't come back, so he went out looking for her. And according to the criminal complaint, he found her bicycle in a wooded area, but no sign of Lily. So he calls police, a large search was launched, and Lily's body was found the next day, partially covered in leaves. According to investigators, evidence indicated that she had been strangled, sexually assaulted, and beaten with a large stick. The criminal complaint filed in Chippewa County Circuit Court says that Carson Peters-Berger allegedly confessed to law enforcement that he killed Lily and sexually assaulted her body. Now, Peters-Berger has been charged with first-degree intentional homicide, first-degree sexual assault, and first-degree sexual assault of a child under 13, resulting in great bodily harm. He faces a mandatory life sentence if he's convicted on that homicide charge. And under Wisconsin law, certain crimes that are committed by a person over the age of 10, they are automatically moved into adult court, and one of those is intentional homicide. But the defense has been very adamant in fighting for their client Peters-Berger's case to stay in juvenile court. And they requested a reverse waiver hearing, meaning the case would go back to the juvenile system. So I want to talk about this, and I want to bring in criminal defense attorney Diane Menashe to talk more about it. Diane, thanks so much for coming here on Sidebar to talk about what is a very, very difficult case. What are your thoughts on trying this case in adult court versus juvenile court? And also, if you can explain to our audience what the significance of that is. What are the differences between juvenile court and adult court?
Well, the difference is, I think, really most importantly on the back end, Jesse, about how that individual might be incarcerated. If you're charged and convicted as a juvenile, then you're held in, a juvenile detention center. You can be held, though, certainly until you're 21 in such a center, versus if you're tried and convicted as an adult, then obviously you go to prison, whatever the state prison system is. I think what's really important about the work on behalf of the defendant or the juvenile in this situation that's so critical here is that while he's 17 now, as I was reading the facts of the case, he was 14 at the alleged time of the offense. And so, Jesse, everything we know, right, about brain development, particularly with respect to males, is that the brain doesn't fully form, that prefrontal cortex doesn't fully form until the mid-20s. So to be trying a 14-year-old as an adult, well, it certainly explains why his defense team is trying so hard to get that reverse waiver and have him tried in juvenile court and not as an adult.
Let's talk about that, because as part of that reverse waiver hearing, his defense team called 10 witnesses to testify. The state called none, by the way. They just relied on the autopsy, I guess the shocking nature of this autopsy, other investigative reports that were already submitted to the court. That's what they relied on. But the multiple experts who testified for the defense about Peters-Berger's rough upbringing and the issues with psychological disorders. According to court documents, the defendant's father went to prison for 3 years for possession of child pornography, also found in possession of several crack pipes. The boy's parents divorced when the defendant was 2. They had joint custody. When his son was charged, Adam T. Berger was reportedly living in a halfway house in Wisconsin after being released from Oshkosh Correctional Institution. This is according to the Daily Mail. And then, according to an obituary that ran in the Leader Telegram, Adam T. Berger died on December 4th, 2022. So this was months after his son's arrest. Now, by the way, with 2025 here, as we're covering these new cases, What do you want your year to look like? Maybe work out more, maybe read a few more books, maybe it's to be the best version of yourself. And that's where the sponsor of this episode of Sidebar comes in, BetterHelp. So BetterHelp is fully online therapy. They've made therapy affordable, convenient, which makes sense considering they're now serving over 5 million people worldwide. Also, you can easily switch therapists at any time. There's no extra cost. This is not about just trauma, but issues with yourself or relationships. So right now, you can visit betterhelp.com/sidebar today to get 10% off of your first month. That's BetterHelp, HELP.com/sidebar. In the end, the circuit court judge found that Peters-Berger's case should stay in adult court. So Diane, talk to me about the evidence that was presented. What are the issues here? What were they trying to show? And why do you think it wasn't successful at that level before we even talk about what happened at the Court of Appeals?
You know, I was in preparation today, I was reading a lot of what you just talked about was the evidence that was presented. And Jesse, the focus was really on trauma, right? This is an individual who has significantly experienced trauma in his life. And the reason why trauma is now so important, as we know, is we know how it impacts brain development. And of course, for the state of Ohio or the state of Wisconsin or any state to be able to approve this type of crime, they need to focus on that mens rea element, right? The intent, if you will. So, you know, his state of mind or his thinking is so critical. The trauma, as I was reading what was presented, was really significant. Not just, you know, under his father incarcerated, but the neglect. There was also physical and emotional abuse. And you know, it seemed like cumulatively his defense team was just saying that this person, right, and his sort of level of thinking is not that of which should be tried in adult court. I was pretty surprised they lost, to tell you the truth. But I think, Jesse, you kind of hit on it. It seems like the judge in the court is just focusing solely on the sheer facts of the case. While they said that there was a confession, it would be very interesting to see, you know, how was the juvenile really speaking or conveying that message to law enforcement. And I couldn't find anything where there was a transcript or video of it, not surprisingly given the nature of the case. But that I'm sure would be very insightful into his mindset.
That's a really, really good point, and I want to get into what he allegedly said during that confession, or that alleged confession in a minute. But then the defense took this to the Wisconsin Court of Appeals. So they're trying now this higher court to reverse that, and maybe his case will be moved to juvenile court. And in the appellant brief from April of 2024, the teen suspect is referred to as CTPB, so this includes his middle initial and double last name. Now, the attorneys wrote about the testimony from several psychologists who interacted with the defendant. Quote, Dr. Caldwell diagnosed CTPB with autism spectrum disorder and unspecified anxiety disorder and testified that his clinical needs supported transfer to juvenile court. Dr. Benson diagnosed CTPB with autism spectrum disorder and persistent depressive disorder. He testified that CTPB's treatment needs cannot be met in the adult system. Dr. Garbarino testified that CTPB's offense is characteristic of an adolescent crisis and that supervision until age 25 would be sufficient to address and overcome the adolescent crisis and would not depreciate the seriousness of the offense. And the defense team also noted in its brief that Dr. Caldwell believed that the suspect's social functioning was on par with a kindergartner, and this was despite him being 14 at the time. Our understanding is Peters-Berger apparently turned 17 this March. Dr. Benson testified that Peters-Berger's emotional maturity is in the range of 4 to 6 years of age. So, Diane, before we move on here, your thoughts on this, because the counterargument could be, well, you know, despite this, you know, a lot of their concerns are he's not going to get the necessary treatment that he needs in the adult system. Is that enough to move it to the adult system? And B, you know, is it more his age and the deficiencies he had or allegedly had that require him to be in juvenile court and potentially being released versus you have people, adults who have similar conditions, and yet they're tried in adult court and they serve, you know, the remainder of their life behind bars. I mean, what should we be thinking about? Because it's a very complicated case.
But Jesse, we know from, you know, the United States Supreme Court that juveniles should be treated differently in the criminal justice system. Like They just should be. And particularly we know that because of, you know, brain development. And of course, brain development also impacts our emotional maturity or immaturity. But the one doctor that indicates that emotionally he's operating at a level of a kindergartner, or even, 4 to 6 or 10 years of age. I mean, we all just know just from common sense. I mean, that is incredibly, right, like young thinking and functioning. And while your point is, well, Diane, there's a 22-year-old that might be emotionally immature. Why should this individual be treated differently from the 22-year-old? Well, the 22-year-old brain is different. I mean, it just is. And also, I don't think we can underscore the trauma piece. I mean, we have a 14-year-old, right, that we know has suffered from significant trauma and clearly has some intellectual functioning and or mental health issues, kind of couple that. And you've got really what happened here. And really indicating 25 in the state where this is being prosecuted. I mean, that still is 8-10 years where this person could be, institutionalized, incarcerated, and receive the help that he actually needs.
Let me ask you this. Putting aside the issue of whether this case should be tried in an adult system or a juvenile system, could any of that evidence, could any of those doctor evaluations be used as a legal defense to what he's being charged with?
I would certainly think pre-trial with respect to this alleged confession. There's got to be a Miranda issue here, right? And as we know, that a waiver has to be intelligent, knowingly, and voluntary. And if we've got an individual that emotionally and intellectually is operating at, in a single-digit age range, I would think that there would certainly be a great suppression issue with respect to the alleged confession. I think that's obviously pretrial and not before the jury. But then I also think that with respect to the mens rea, I would certainly anticipate the defense really trying to push and introduce this testimony in front of the jury that this individual just didn't have the mental capacity to form the mental state necessary for the state to meet their burden of proof.
Now, the defense, they also noted that this teen has an addiction to pornography. It was exacerbated by his autism disorder. It reads, in this case, everyone agrees that CTPB should be punished. The question is both how and how much should we punish him. By placing CTPB in juvenile court, he will receive the punishment he deserves while also receiving the help he needs. This outcome will not depreciate the seriousness of the offense. But in its decision, filed in September of 2024, the Court of Appeals refers to Peters-Berger by the pseudonym Christopher, and it states, Christopher appeals a non-final order denying his petition for reverse waiver into juvenile court. The circuit court concluded that Christopher had not met his burden to show that transferring jurisdiction to the juvenile court would not depreciate the seriousness of Christopher's offenses. On appeal, Christopher argues that the court erroneously exercised its discretion in that regard. We disagree and affirm the order denying Christopher's petition for reverse waiver. So the appeals court agreed with the original judge, saying that he'd ruled correctly, meaning this case was good to proceed in adult court. Diane, your reaction to that, and also your reaction to the defense seemingly suggesting, yeah, he's going to be convicted. It's just a matter of what his punishment in his life should be.
When I read that that's what the Court of Appeals decided, my instinct or my first thought was, if this isn't a case that should stay in juvenile court, and we know that there's an exception, right? The statute allows for some homicides to be tried in juvenile court and not to be bound over. If this isn't that case, then why is there even an exception? Why is there even a reverse waiver? And I think for me, that's really what's rooted in here. We had 10 experts. This individual suffered a significant amount of trauma, 14 at the time of the offense, not 17, not even 15 or 16. I mean, 14 is a true juvenile, right? That is an adolescent in every, way that we can describe it. So it really sort of, the court saying, again, well, the facts of the case are so egregious that this has to be tried in adult court. But the statute takes into account egregious facts, yet there's still an exception. There's still an ability for such a case to be in juvenile court. So, Jesse, for me, it just rings true in one of those cases of, Rule 29. I always think, once in a lifetime, I'll argue a Rule 29. And I think if this isn't a case that should be, dismissed before going to jury, what is? That strikes me as the court's decision in this case as well.
Now I want to go back to what you mentioned, the alleged confession, because this filing does give us some more background on the case, the investigation, including the suspect's alleged confession. It reads, Christopher told police that he and the victim left a house together with the victim on her bicycle and Christopher on a hoverboard. Christopher admitted that when they left the house, quote, it was already his intention to rape and kill the victim. Christopher and the victim were initially on a trail, but Christopher asked the victim to go exploring off the trail, and they proceeded into the woods. After they left the trail, Christopher punched the victim in the stomach, knocking her to the ground, and struck her in the head approximately 3 times with a stick. Christopher then straddled the victim, who was lying on her back, and strangled her until he believed she was dead. At that point, Christopher removed the victim's pants and began trying to have sex with her. Christopher told the police that he remembered biting the victim, but he could not recall where. At some point during his assault of the victim, Christopher became scared and fled the area. He returned home, showered, put his dirty clothes in the laundry. When Christopher heard that the victim was reported missing, he decided that he needed to hide her body better. He therefore returned to the location of her body, dragged her body a few feet, and covered it with leaves. So Diane, what you're basically seeing here, if you take it as true, is somebody who is admitted to killing this girl and was trying to cover up the crime, and even at a young age. Now, the question would be, how do you argue against this confession? You're right, I haven't seen a transcript of it. You're right, I haven't seen a transcript, but would the argument be that police are not telling the truth about that confession, that they have a different characterization of what he said? What would you be looking for? Because that confession, I mean, it's really bad for the defense.
Certainly, as you said it, it's really bad. You know, using the word rape and sex, there's a lot of words, even as you're saying it, that are adult words, right? So I think the first thing is when we look at the interview, and we can only hope that it's been video recorded, at least audio, is just how leading, right, is the investigative agency being when they're interviewing this juvenile? I mean, are they saying, you bit her? We know you bit her. Come on, just tell us you bit her. And then ultimately he says, okay, I bit her. And then they say, well, where? And he says, I don't know. Right. So I think the first thing that really needs to be focused on when you're looking at from the defense side is, you know, how suggestive was the interview? Also, the duration of the interview, how the story changed. Did he begin the interview saying, I had nothing to do with it whatsoever? I think also his emotional demeanor, and critically, Jesse, the words that he uses during the interview. Because I haven't seen it, obviously, but I can assure you, it's hard to imagine he uses the exact words that I just heard from you that are being reported. You know, how does he describe, you know, the sexual intercourse or conduct? How does he describe that? And then lastly, I would just say, I think one of the things to really keep in mind is what we know is that, you know, individuals that commit sex offenses, you know, 99% of them, and truly that number is staggeringly high, are victims of sex offenses themselves, sure. Right? So is this reactive perpetration? What is really going on here with respect to the sex offense and also the strangulation piece? But I think, Jesse, while I know it sounds like from the surface a dead bang loser, I trust that there will be a lot to work with respect to that confession when it's all said and done.
And what's backed up by the other evidence? Because there was this autopsy details Lily's extensive injuries that a forensics team said that DNA found on her body matched the defendant. I wonder, Diane, does the defense even challenge that?
That's an interesting thing. I certainly try a lot of cases where, you know, strategically, right, you want to be authentic. And it seems like this case is a case really about mental state or lack thereof. And it sounds as if there's likely to be witnesses that put them together beforehand. So I think there's maybe a case where you really do, you know, depending on where the DNA is found, right? I
don't want to get too graphic, but I will just say we've read some filings and it's reportedly in key locations.
Key locations, then I think at a minimum, Jesse, I would do what I always do, which is have an expert look at the testing, certainly in the analysis. And then strategically, I think just got to figure out, you know, how do you put together the case with really focusing on your strongest argument? And in this case, it's just going to be the mental element.
Yeah, I agree with you. I think that's really where they need to focus on. One more question I had for you, and it goes back to this. So in December of 2024, there was an arraignment for Peters-Berger, and it was finally held. It was more than 2 years after Lily was killed. The suspect appeared virtually, was not shown on camera, chose to stand silent, meaning the judge entered not guilty pleas on his behalf. But when it came to scheduling a trial date, there was some tension between the prosecution and defense.
Judge, regarding scheduling, Mr. Newell has asked me a number of times to consider setting a trial date. It makes him feel that I'll find something probably in 2026. But I don't know that there's a benefit to setting some artificial trial date that likely is going to have to be moved or adjusted depending on what happens in the motion hearing. We have no idea the number of witnesses, how long we're going to be needing, if this is going to be a 2-week case, 30-day case. I'm not in a position to say that at this point, and I'm not going to speculate. It seems to me that the most prudent thing to do is have the hearing in April, see what happens with the court's ruling, get to what I believe will be some significant motions, which will likely determine what happens at trial, and then we'll be in a better position to schedule something.
And the judge told the attorneys that he expects a motion will be filed for change of venue. So a motions hearing was set for April, but according to the court calendar, that has now been pushed to June. Diane, the venue issue I find very interesting. So I'm not sure if that would mean moving the proceedings, or maybe it's just bringing in another jury from a different county. But it feels like a change of venue, whatever you want to call it, feels like that might be necessary in this kind of case when you're talking about the victim and how she died and what happened to her. It feels like maybe bringing in another jury who's not inundated with this information in this community seems like a wise decision, no?
From my experience, certainly the way we do it here in Ohio is change of venue would be physically moving the case to a different jurisdiction. So your jury pool would be different. I don't disagree with you necessarily, although, certainly the problem with the change of venue, Jesse, is like you don't know what you're going to get. So right. you could actually get, a more conservative, more rural jurisdiction that, particularly for a set of facts like this, might not be to your benefit. I am just sort of making gross generalizations here. I always change of venues, quite frankly, even in really high publicity cases, which I've certainly done. I generally just don't file them because I think, every county, even if you move it, then that county is going to be saturated with the media because it will be in that county. So there certainly is, we go through the voir dire process for a reason. You've got to do the voir dire right and make sure that you've got a fair and impartial jury. And I understand media exposure and I understand the real concern about a change of venue. But I'm always of the mindset that as many pieces as you can control and know, the better. And a change of venue is like, let's get it out of here, but you just don't know where it'll go.
It's a really valid concern. And defense attorneys and prosecutors, they are faced with that in trials and cases around the country. But Diane Menashe, listen, thank you so much for taking the time. I know this is not an easy case to talk about, but really appreciate your perspective and breaking down what has happened and what we might be able to expect. So Diane, thanks so much.
Absolutely. Thanks for having me.
And that is all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.